So what they're actually doing, what the police chiefs are actually doing to us now, is that they are sending a photograph and a letter to you and saying, if you do not admit to this crime, you know, they're threatening you. But what they're saying is they are going to, if you admit to it and accept, you know, these points, penalty points, which is a punishment, right? If you accept the penalty points, which is a punishment, and admit on this information, will restrict your punishment, you know, because, you know, it's just a conditional offer. Oh, we'll just give you 3 points and a fine rather than having to go to court and get convicted. But it's still a form of punishment. So the forcing of ledgers, which is knowledge, to depone against themselves in capital crime, however the punishment may be restricted, is contrary to law. So that means that forcing you to admit a crime and accept some sort of punishment, even though it's a reduced or restricted punishment, on the information, forcing you into it, is illegal. The forcing of ledgers, knowledge to depone against themselves in capital crimes, however the punishment may be restricted, is contrary to law. Well, that's like a conditional offer that the police chief gives us. It's illegal. When you get arrested, you have the right to remain silent. Anything you can or will say, or sorry, anything you do say will be used against you in a court of law, right? But, you know, when you go into court, you're on oath that what you do say is the truth, you know. But they can't actually force you to speak. And when you're getting arrested. Now, the thing with, they're actually saying that with the fixed penalties, all fixed penalties and fines, they don't actually take you to court, do they? You don't go to court. Why? Because they say if they force you to pay money, which is a punishment, or accept some sort of penalty points, accept these penalty points, right? Accept the penalty points. It's a punishment, right? You take them and then you don't have to go to court in front of a judge on information or even on your own witness statement. It doesn't matter. It says that the forcing of of informations to depone against themselves in capital crimes, whether the punishment be restricted contrary to law. So they're getting you to basically admit it, because if you go to court, you're going to say that I didn't do this and your evidence is wrong. But if you admit it, you're admitting it on basis of your own knowledge, because they can't actually convict you really without you. They need you. So, you know, you enter a plea, because even if, you know, by post you can even enter a plea and not turn up or whatever, but usually if you just don't turn up and don't go in there, if they just, you know, summons you, for example, and they can convict you without you turning up, but usually you enter a plea, you can enter a plea by post, but in a lot of instances, they actually, if you don't turn up, sometimes they send the police to get you, and then they take you in, and then they say, how do you plea? You know, I'm not too sure what happens if you use your right to remain silent at the plea stage. When I'm not going to speak, I'm not going to enter a plea, or say anything, you know, even when you're compelled to, you know, even when you go on to under oath. But I think that oath's about when you do speak, you speak the truth. I'm not too sure how silent you can actually remain in there. But what this actually is saying, it's that however the punishment be restricted is contrary to law. So what they're doing is it's about forcing you. The forcing of informations in order to basically get yourselves convicted for capital crimes, or however the punishment be restricted. Well, it's a punishment, isn't it? You get 3 points, it's a punishment, and then if you get it a few more times, then then they take your licence off you. It's a fine, and you get a fine as well. So a fine's punishment, but the police are actually issuing it. The police are actually making you take a punishment. This is, according to this, that's actually illegal. Because you should actually have to go to a court. The use of torture without evidence or in ordinary crimes is contrary to law. The use of torture without evidence or in ordinary crimes is contrary to law. Well, what's the capital crimes? False knowledge is to burn themselves in capital crimes, however the punishment be restricted, is contrary to law. The use of torture without evidence or in ordinary crimes is contrary to law. Well, so they can't. They used to be able to torture people in ordinary crimes. They used to be able to torture people with evidence if it was capital crimes, but not in ordinary crimes. I'm sure that the punishment may be restricted. And that the use of torture without evidence or forcing people to provide information in capital crimes where the punishment may be restricted. So, like, that's like forcing information. Maybe saying if you don't, like, confess, if you confess, basically, if you confess, we will not torture you as much, or we won't torture you if it's a capital crime. If you confess, we won't torture you, basically. So we will, because, well, the torture is punishment, surely. Torture actually is a form of punishment anyway, isn't it? So if you're getting tortured, then surely that is punishment. I mean, they were hanging people. The use of torture without evidence or in ordinary crimes is contrary to law. So that means they can use it with evidence. If they've got evidence, then they can torture you, but not in normal crimes. The false knowledge to burn themselves in capital crimes, however the punishment be restricted, is contrary to law. So basically, you know, why would you be tortured there? If you did have evidence and they were torturing, why would they be tortured? If it's illegal to get information out of people, why would the punishment be restricted? That would suggest that they can't force you to give information. Or if they're saying if they reduce a punishment, if you confess and reduce a punishment, but that's basically that's the same principle. That is the same principle as what's happening with the speeding fines, isn't it? You know, if you take these points and pay the fine, we won't take you to court if you admit. So it's forcing you. It's forcing informations to make you admit something if you take but that's almost like trying to get people to admit their guilt. You know, if you plead guilty, you won't get a severe punishment. You know, it's almost like, you know, if you plead, you know, if people plead guilty, then, you know, the court will be on. But you're meant to be prosecuted on the merit of the crime, if the crime's serious or not. You know, all this thing that if you confess, but that's the thing. That's the thing. Well, if you don't think that you are guilty and they lure you, you know, they say, well, you know, if you actually admit that you're guilty, you know, we'll go easy on you, basically, but you might not even be guilty. So it's actually making you, you know, saying, you know, if you say you're not guilty and try and prove it, but you're found guilty, then, you know, they're going to be harder on you. But that's not fair, because if you truly believe that you weren't guilty, why should you have a more severe punishment just because you pleaded the other way? You know, at the end of the day, if you're found guilty of the crime, then, you know, you should be punished for what you did or didn't do. You know, if you actually are, you know, trying to prove you didn't do it because you didn't believe that you did it, and there's a case for that, but they didn't believe it though, but you believed it, then the actual, you know, that would almost mean, like, you know, you don't have a right to claim that you know, innocence, you know, and then if you don't have a right to claim innocence, you might as well not have a plea. So therefore, if you've never got a plea, they always think that they're always proceeding with guilt. You don't have the right to a defence. You don't have a right to a defence because, you know, there's a fundamental thing with the court case, and that is that when you are entering a defence, you are defending it, right? If you admit that you're guilty, then you can give these mitigating circumstances, which is almost like, you know, all right, I did it, but, you know, you can give excuses or apologise and so what, but that's not a defence because you've actually plead guilty. It's meant to actually, if you plead guilty and you say you did do it on the information, if you did do it, and you know, but, you know, you can give mitigating circumstances to restrict the punishment, try to get it lowered. But that's different from if you don't think that you did it and you've got a case to prove, because if you admit you're guilty, you actually don't have a case to prove. You're not actually proving a case. It's not your case. You're not setting out a case for I didn't do this, you know, and going to attempt to prove it. And if it doesn't fail, if it fails and it doesn't succeed, and, you know, you lose, but you know, you attempted to prove that and you had the right to, but they just didn't believe it, right? But at the end of the day, what did you or didn't you do? And, you know, there's a certain sentence for that, whatever you did, and that sentence surely should be the same, you know, regardless, because, you know, you're getting punished for what you did or didn't do. You know, you've got to try and prove you didn't do it. But if you did do it and you admit that you did it straight away, you can put mitigating circumstances, but then they haven't forced you to do that. Because there's a difference. In my court case, that they attempted to try say it was too busy. They have two different courtrooms, and one is for guilty pleas and one is for innocent pleas, and then they tried to say that they were too busy in the courtroom where people are pleading not guilty, you know. So they tried to force me to change my plea because they said they were too busy, and that's not even using knowledge. That's just them giving like some sort of blag or excuse. So I would like to look into this further. It does say for capital crimes, but at the end of the day, you know, is that the difference between just summary cases and indictments, you know? At the end of the day, surely crimes are crimes, aren't they? Ordinary crimes. I still, because even some like you know, some of the road traffic and fines can be serious, like whether it's, you know, like the dangerous driving or anything like that, you know. Those are considered as serious crimes. I still think that the principle of getting you to accept some form of punishment that is a reduced punishment, if you forcing you into it, because the thing is, with once they've got your photograph, they don't persist, they don't desist, they just continue with it. There's no other way out of it, you know. But what they're doing is getting you to, you know, you don't get a fair trial, you know. They're actually getting you to admit, and you might not think that you're guilty, you might think that you're innocent, but what they're doing is they're getting you to admit the crime and accept a punishment that's restricted, you know, going on informations or even give informations. Well, the thing is, you are, because, you know, if you say, yes, I did it, that's an information. If you, basically, an admission is an information. if you admit, if they say, oh, you did this or you did that, right, you know, forcing of ledgers, that basically means that, you know, you are going to square up with them. You know, but you're going to incriminate yourself, to depone against themselves, incriminate yourself, depone against yourselves. However, the punishment be restricted is contrary to law. So they're trying to get you to, you know, basically admit on a restricted punishment. For basically admit a crime for a restricted punishment. Even without a trial as well. Also, what's worse is even without going to court and without a fair trial as well, which is worse. I think that the speeding fines are illegal. I think that the whole N.I.P., Notice of Intended Prosecution, is racketeering because it's threatening you. It's threatening legal action, using informations and getting you to confess, admit a ledger in order to depone yourself in a crime, in a criminal charge, for a restricted punishment. So there's definitely, if someone, we need to get someone to actually look into this. Because basically, right, the thing with a normal, actually, on this other line here, if you want to say, well, there's a difference between ordinary crimes, you know, you can't be tortured for ordinary crimes or whatever, but what about a parking fine? Because a parking fine is, it's not criminal, is it? A parking fine is, I don't think it's a criminal offence. Even if you pay it and admit that you parked illegally, you don't get a criminal charge, do you? You don't get a criminal charge. But if you don't pay the fine, then the council take you to court to make you pay it. Or if you don't pay it, they send the bailiffs round. So there's a court involved and you have to pay a charge. Now that wouldn't be, you're not actually a criminal. You know, you haven't broken a crime. It's a parking fine. It's not a criminal charge. So, you know, getting you to pay up for parking fines is different to something that is an offence. You know, if you exceed the speed limit, blah, 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 it is a criminal offence, a crime. You know, so it classes as crime. I really think there's a court case for this. I really think that there's a court case for this. Because what I've found is all of the laws that there are, they've been somehow breaking them or find a way to break them. They seem to like to do that. Like the right to petition, they totally ignore it. And like Angela Ditchfield, the prosecutor, I actually think that those N.I.P.s, Notice of Intended Prosecutions, conditional, you know, these conditional offer from a police chief. It's a conditional offer from a police chief. I think that they're illegal under this Claim of Right Act, which is basically similar to the Bill of Rights. I'm just getting onto the other parts of it. Look, this is the same as this part's the same as the right to petition here, but it's slightly different. That is the right of the subjects to petition the king, and that all imprisonments and prosecutions for such petitioning are contrary to law. Right? So you can't, for petitioning Parliament, the government, either of the houses, the king, you can't actually be imprisoned or prosecuted. And you're actually bringing a case. You're actually bringing a case, and you need, obviously, you need evidence for that to obtain evidence, you know. And some of the other ones out of here, this Claim of Right Act 1689, these are some things that have just stood out to me now. That the imprisoning persons without expressing the reason thereof and delaying to put them to trial is contrary to law. And delaying to put them to trial. So some of those protesters have been put in prison without a trial. It says and, not or. So obviously they're expressing a reason if you've done something, right? But they're not allowed to delay going to trial, but they are doing. And that this claim of act right would mean that they can't make any laws to do that. They can't make up any laws. They're not allowed to, like, you know, Congress shall make no law. They're not allowed to make no laws. That they're causing pursuit and forfeiture of persons upon stretches of old and obsolete laws, upon frivolous and weak pretense, upon lame and defective probation, as particularly in the late Earl of Argyll, are contrary to law. So this is, I mean, you might wonder if that gives a hint at whether you're, you know, if you're petitioning, whether you've got weak pretenses, you know, whether your case to the government is weak or not. Well, the ironic thing with this is the Petitions Committee at Parliament, when you're submitting a case to the government, through that, they restrict how many characters you can put. So, like, you know, you can only write 50 characters or 50 words or whatever it is, a very small number. So you're never going to get a strong pretense, a strong case to the government. When they're restricted, they don't let you attach any documents, or they don't really let you use any off-site websites. This is Martin Day, MP, and that Geordie woman, that Labour woman. They are basically rigging it so you can only submit very, very weak cases. And when you collect 100,000 signatures on something, that has got to be more serious than any, you know, local parking fine or even a speeding ticket, you know. You're getting 100,000 people. I mean, even when you go to a court, people are getting convicted with a jury, 12 people. Anyone who goes and gets, you know, 100,000 people on something, it's no weak pretense. Now, when they get signing up to a bit of information that you've submitted or some evidence and it's restricted to 50 words, you've got the weakest case possible, you know. But what I think with this is, you know, lame and defective probation. Well, that's mine because I was prosecuted illegally anyway, petitioning the government and not even the local council to the main government. That causing pursuit and forfeit persons upon stretches of old and obsolete laws. Well, I think that might be signalling to the 1661 Tumultuous Petitioning Act. I'm quite certain that's relevant to the Tumultuous Petitioning Act, you know, the Tumultuous Petitioning Act, because that was at this time, in 1689, it was 1661, so it was 40 years old. Maybe the government currently think that the Bill of Rights is not valid, that they're causing pursuit and forfeit of persons on stretches of old and obsolete laws. Maybe they think they're old and obsolete, that our Constitution's old and maybe they think that the Bill of Rights is old and obsolete, but if we didn't have it, we wouldn't have any rights at all, you know. Frivolous and weak pretenses upon lame and defective probation, as particularly in causing pursuit of forfeiture from persons upon stretches laws upon frivolous and weak pretenses. So basically, if they haven't got a strong case against you, this is the, you know, this is the thing with all the speeding fines as well. You know, take a photograph. You know, all they do is send these photos in, you know, and then, you know, they don't have any other persons involved. It's just a machine. You know, a machine takes a photograph, and apparently their machines, you know, are more valuable than a person. Like these new robot dogs, you know, or even frivolous. You know, a lot of the fines are frivolous anyway. You know, parking fines, a lot of speeding tickets. You know, when there's an empty road, a lot of those things are frivolous. You know, frivolous matters. You know, like, you know, it's a complete straight dual carriageway. There's nothing on it. It's sunny. You know, and you're going a few miles an hour over the speed limit, right? That would be frivolous, surely. You know, I know that it's not old and obsolete legislation, but then again, what about the legislation in the Magna Carta that you can't have your cart for work taken off you? And that's carried over into the Highways Act by saying that, you know, if you're working for an employer and you've got a timetable and a round, you know, and you've got to get round it, you know, that then it's used as a defence. I think this frivolous and weak pretences. There's definitely something in that, in this, the nominating and imposing the magistrates and councils and clerks upon boroughs contrary to their liberties and express charters is contrary to law. The nominating and imposing magistrates, councils and clerks upon boroughs contrary to their liberties and express charters is contrary to law. So using magistrates and clerks court contrary to people's liberties is contrary to law in the areas. Well, what liberties would you have? Well, this is the thing. If you're petitioning the government, it's not a local matter, is it? If you're petitioning the government, it's not a local matter. You know, for example, you know, if you're wanting, you know, the whole tax in the country to be changed, that's not a local matter. Or, you know, if you were living in, you know, Yorkshire, but it's a petition about saving Stonehenge that you're organising, that's not a local matter. But if it is a local matter, then it usually goes to a local court. Surely that's got some bearing of relation to that. This one underneath here is really, really interesting. The sending of letters to the courts of justice ordaining the judges to stop or desist from determining cases, or ordaining them on how to proceed in cases depending before them, and the changing of nature of judges in gifts. What about, you know, all these judges who are getting gifts from oil investments, investing money, and they're judging these cases that are connected to that? Because, you know, there's something in this for, if judges are working for the government, but they're friends with Rishi Sunak and they've got a nice tidy investment in a company, like that Emma Arbuthnot was accused of that. Emma Arbuthnot was accused of, you know, having shares in her husband in a lot of things, you know, and they're making certain orders that are favourable to their investors and so forth. Although this is the problem with Sunak, you know, because it depending before and changing of their nature. So that's the way that they're behaving or acting or conducting themselves, you know, in gifts and into commissions. So our country to law. So basically this is bribing judges but also giving them gifts. This is the thing. What happens if Rishi Sunak, you know, is at his, you know, a dinner party and he's speaking to a judge and he goes, oh, would you like some shares in this business? I'd invest in them if I was you. It could make you a very tidy, wealthy, you know, man, judge. Why don't you come and invest in Rishi Sunak's wife's companies? And then, you know, this is the thing. Oh, Rishi's just done me a favour. And, like, you know, I'm doing this court case. Someone's trying to prove that, you know, all our government processes are corrupt. And, oh, I'll have to be on my friend Rishi's side with that tiny investment that I've got with him. This is the thing. His job's meant to be a judge. He's not meant to be, you know, investing in companies and so forth. I think their definition of gifts is pretty, you know, like, you know, here's a ham sandwich or whatever, or, you know, here's a tidy, you know, bribe under the table or whatever, or I'm having a free car or whatever. But still, when the thing is at the moment, with all these investments and shares, which we know they're all involved in, they are getting benefits out of certain things. And if he's keeping, you know, Rishi Sunak and shareholders and Shell happy, this is the thing with Emma Arbuthnot. This clause is relevant to that. We've said that one underneath, that forcing people with information as if they get a restricted, reduced punishments. The freedom of speech and debates in Parliament. Well, so I've also got this the full text for this Tumultuous Petitioning Act. This 1661 Tumultuous Petitioning Act, I've got the full text now. And it actually is, this 1661 Act, if you're petitioning Parliament, the King or both either of houses, right? There. The King or both or either of houses, you had to get it, the petition had to go through the courts. Like, the matter have been first consented into and ordered by 3 or more justices of that county, or by the major part of a grand jury of the county or division of the county, where the same matter shall arise. Well, that's the thing, where the same matter shall arise. Now, what happens if it's a Stonehenge petition, but I'm in Yorkshire, but we're going to try save Stonehenge? Well, the matter is arising in Wiltshire. So that's the thing. If, like, Stonehenge had done that petition, then it would have had to go through a grand jury or court in Wiltshire first, right? And then to Parliament. Which, when people have been submitting 15-minute say petitions, Parliament has been diverting them to Wiltshire. Or wherever it is for 15 minutes. Sorry, to Oxford, you know, or wherever the 15-minute cities are. Which you can petition the local council. Really, you can get a local referendum, that's the thing. So for those Stonehenge petitions... But the thing is, this act was scrapped. This act was scrapped, this 1661 Act. So, they can't actually make you go to a court or through any justices or jury for matters that you're petitioning the government, right? And even if you are petitioning the government, there's no matter that shall arise. If the matter is the taxation of the whole country, then surely that matter has arisen in Parliament anyway. So this, I think this is more like making you say that, you know, petitions about a local area have to go through there, you know, not, you know. But then again, you know, shouldn't that matter have been petitioned to the local council authority anyway? But it doesn't really matter, because now it doesn't go through there. All lot of the articles. This act or anything shall not be construed to extend or debar or hinder any person or persons not exceeding the number of... not to present any public or private grievance or complaint to any member of Parliament after his election. So it did go through MPs. So your MPs are like your solicitor or your lawyer. That's the you see, with YouTube complaints, when we've got videos on YouTube for petitions, and if you've got an issue with the video, you aren't really supposed to get a lawyer, because it's it's a casework to Parliament, and your MP is the authority that we've elected to represent us. So they really are meant to be our advocates, you know. And during the continuance of Parliament, so if there was, should not be no exceeding number of 20. So you actually, to petition, if you had under 20 people, you could still present a petition to your local MP. This is strange, though, because the more and more people you get, then you actually got yourself a local court session. But if you didn't, then you couldn't give it to your MP. But you actually got a court case about the petitions. Now, if there's any trouble or hassle or issues around petitions, like Extinction Rebellion, they're making people go to court in connection with those cases. And it's well, it is over 20, you know, but this was scrapped, so... And this is also, this bit is quite useful here, look. Whereas it have been found by sad experience that tumultuous and other disorderly soliciting and procuring of hands of private persons to petitions complaints, remonstrances and declarations are never addressed to the King or to both either houses of Parliament for alteration or matters established by law, redress of grievances or pretend grievances in church, state, or other public concernments. So this is all the things that you can, you know, raise a case about, have been made use of serve the ends of petition and seditious petitions got into power. To the violation of the public peace. Right, so violations of public peace. That's basically what Extinction Rebellion keep getting pulled on. And have been a great means of the late unhappy wars, confusions, calamities, for preventing like mischiefs in the future. So that's what they're up to now, mischiefs. So this is the subject matter of what all these activities are absolutely concerning. Because this is the Tumultuous Petitioning Act, and because this is concerning what would be covered by this petitioning, what concerns it when we use the words is in this act, all matters in this act. And some of the matters in this act are mischiefs. You know, so it does actually cover, you know, all these kind of like actions or demonstrations, protests, or possibly even, you know, even things like what Angela Ditchfield did. But the Angela Ditchfield case with the paint is already covered in modern law. It's all explicitly and specifically covered in modern law. So it's not a mischief in the sense of it being illegal, because it's lawful. So in this act, this is under Charles, you see, after, you know, Oliver Cromwell and all the Civil War. This is when, you know, the throne takes back over, and then they're cutting back on all this. And then this is when later on, it is the right of the subjects to petition the king, and that all, right, they've got quite a diverse use of language in these now. They're not limited for words. They didn't have to say all of them. The right of the subjects to petition the king, and all imprisonments and prosecutions for such petition are contrary to law. All imprisonments and prosecutions. So that must actually cover the mischiefs, because we're on the right subject, and that these acts are what basically got the rights back, you know. So we are protected, and it also, you know, this in the 1688 bill, when it says that, you know, the illegal prosecutions, well, all prosecutions and imprisonments are contrary to law. So we get onto the subject of illegal prosecutions in the 1688 bill, and it's about, this is about evil counsellors, judges and ministers who are subverting the laws and liberties of the kingdom, right? By prosecutions in the court of King's Bench for matters and causes cognisable only in Parliament, and any other diverse and arbitrary and illegal causes. So surely that is also any way of being prosecuted. Surely, you know. So, also, other diverse, arbitrary and illegal causes, like I've separated these with a 1 and a 2 because that's how you write it now, by these and by these. Illegal prosecutions by 1 and 2. So, not only by prosecutions of the Court of the King's Bench, but other arbitrary and illegal causes. Well, what would those illegal causes be? What would they be? Well, any or all, because it says that all commitments. It doesn't say in the King's Bench here or in the local courts. It says all, right? And what would those all be? Surely any diverse, arbitrary and legal causes, because they're all illegal. Any of them which would be, diverse or arbitrary, which is kind of basically, any other creative or ingenious ways or methods that they can think of. And then you go into freedom of speech. I really think that this bit here, I really think that this could be used to say that those N.I.P.s, notices of intended prosecutions, could be illegal because it's getting you to accept, it's forcing a ledger of admittance from you, basically, for a criminal offence, not just a parking fine, an actual criminal offence. Instead of like a parking fine, you pay a fine if you admit it or challenge it. This is actually forcing you to accept a restricted, lowered punishment by, forcing yourself to admit information, to admit, basically to admit guilt. Regardless of what information they've got. I mean, why would they be charging you with it in the first place? So you're not getting a fair trial. And in fact, it says this actually then would fit with that other that the imprisoning of persons without expressing the reason thereof or delaying them put to trial is contrary of law. Well, that's the thing, that you're entitled to a trial and you've got a fair trial. There's a lot of protesters who've been prosecuted by this, but it says, and delaying putting them to trial. Well, the thing is, right, with this, forget about just being locked up, that imprisoning persons without the express reason thereof. But as well as imprisoning, what else is there? And delaying of putting people to trial, or not even giving them a fair trial. Well, if they get you to accept you're a criminal, admit you're a criminal, if you get a reduced punishment, you're not going to get a trial, are you? You're actually deposing yourself. And it's actually, these are criminal offences, not just like a parking fine. It's a crime. Crimes, not just like a fine, a parking fine is not a criminal offence. It's just a fine. I don't think that those N.I.P.s, those notices of intended prosecution with a conditional offer, are legal. I've never thought they're legal because it's like racketeering, it's like bullying, and it's blackmail basically, because it's threats. They're threatening you with legal action. It's always threatening legal action. Pay this fine or have the legal action. Well, you keep paying up. If you get the points, you pay up because you don't want to go to court. And then what happens is you accept this reduced, restricted punishment, And then, but once you've done it 3 times, there's no what you can do, and you have to go to court, and you usually lose unless you pay up a massive amount of money to these, you know, Mr. Loophole or whatever, you know, Nick Freeman. You know, a lot of people don't even turn up and defend themselves. You know, they just hand in, they get automatically banned. You know, you should have a fair trial in the first place, and you shouldn't be blackmailed. I think that this is relevant, and you might say, well, what's capital crime or not? But the thing is, a lot of things aren't even a criminal offence, are they? Like a lot of fines and so forth aren't even offences. Now, you've got offences which are serious, you know, like most are summary. But mine, like, for example, my dangerous driving charge was... It could have been either way. The thing is, it did get dealt with summarily. I didn't get indicted, but summarily charges are meant to be brought within a certain time, and the time they brought against me was well outside of that time. But because they claim it's an either-or offence, they had the right to take as long as they wanted. But I think they've got to decide whether or not, you know, they asked me in the court whether I wanted to be dealt with in the magistrates' court or in the Crown Court. Courts don't usually ask you anything. You know, they do what they're doing. If they're going to, you know, prosecute with a serious crime and take you to... They don't ask, you know, someone who's just murdered someone, oh, would you like it to be dealt with summarily? By giving me the option, they tried to make out that it could have been either or other. Why didn't they ask me that earlier on when they first sent me the letter and I said, oh, I want it to be dealt with in the magistrates' court, right? The thing with my case is this, the insane thing about my case is this. They asked me whether I wanted it to be dealt with in the magistrates' court or Crown Court when it came down to it, and that's when I submitted the right to petition and I got that civil hearing separate from the charge, separate from the trial, right? Now, this is kind of important because when the police were investigating and sent me the letter, they reckoned that, you know, it could be either or. So therefore, they said because this offence can be summarily or can be indictment, they can take as long as they want. But when it came down to it, after all that, they didn't say they're indicting me, like, you know, 12 months later. When I went into a court, she goes, oh, how would you like this dealt with in the magistrates' court or in the Crown Court? Well, I said magistrates, because I'm scared that Crown Court's more serious. But after, if I'd have known what happened to Ian Bray, you know, when he got acquitted, you know, this was before all that happened, I would have probably opted to go to the Crown Court. But saying that, they asked me which I wanted to choose. Now, why didn't they ask me that in the first place? If the judge was going to ask me if I wanted the matter to be dealt with the magistrates' court and the Crown Court, it seems like it's my decision. So when they were investigating it, and when they sent me the letter at the start, by the way, they said that they aren't even sure whether it's, you know, we're charging you possibly for either, you know, driving without care and attention or dangerous driving, which driving without care and attention isn't an indictment. It's only summarily. So they don't have, you know, as much time as they want. But they didn't know for sure. So that is ridiculous. Now, if they think it could be only... you know, driving without due care and attention, you know, without doubt, then why did they drag it on for 12 months, you know? Because that offence would have only took a short amount of time. And at the end of the day, after they got all the evidence, and by the way, this is, you know, before even the trial, you know, the hearing, why did she ask me if I wanted to go in the magistrate's court or not? Because then suddenly that makes, you know, it's me who decides that. So why is it that the police who are deciding it the whole way in order for them to drag it on, but then when it gets to it, they're not, you know, you can decide if it's summarily or indictment, right? I got to choose. Now, the police didn't even know whether it was, you know, driving without due care or dangerous. They were going to, I knew they were going to attempt to, they didn't really, they clearly didn't have enough evidence or know without a doubt whether it was going to be dangerous driving, and they led me to believe that, you know, it likely wasn't. And then after 12 months, then I walk into a court and then say, oh, how would you like this dealt with? And I'm like, what? Well, actually, I want it dealt with summarily, and I'll have the time limit for that. And you're out of time, by the way, because now I've chosen the summarily, then I was supposed to be, prosecuted within a certain time limit, so it's invalid. This is the thing. Even that, the prosecution was illegal in the first place, because I was investigating evidence for my own case to the government, and it isn't actually allowed to be dealt with through the courts, because this 1661 Act has been abolished now. This Tumultuous Petitioning Act, it doesn't go through courts. And I've already got a case that I'm involved in. So, anyway, it's quite a lot to talk about, but if I could this actually is the thing that I wanted to talk about here. And I think this video is like beyond the scope of the local groups. I want to actually ask the ULEZ people about this.